Good afternoon, everyone. Thanks so much for joining us today. We have a full lineup, so I will get started now by going over the agenda and introducing today's panelists. First up, we have Brittany Shep Wong from our New York City office. Britt is going to provide us with a timely update on Title VI admissions data. And next, we will have Candace Gomez from our Long Island office joining us again today. Candace is going to discuss some of the new developments regarding the Safe for Kids Act. And last but certainly not least, we have Stephanie Fedorka from our Rochester office back with us again to provide a quick refresher on New York paid sick leave and a few of the common issues that we've been seeing since the law's implementation. I will now turn the program over to Britt. Britt?
Thanks, Carrie. Good afternoon, everyone. Nice to be back on the Tuesday webinar. Like Carrie said, I'm going to walk us through some updates in the Title VI space affecting higher education institutions on admissions data. Next slide, please. So I think as everyone knows, we've been living in a post-SFFA landscape, the landmark Supreme Court decision a couple years ago regarding affirmative action. And since President Trump took office, we have seen a major uptick in DOJ and other investigations into higher education institutions' admissions practices. They've been announced against a number of schools, Stanford, some of the UC system, George Mason, Harvard, and the list goes on. The California focus is particularly interesting because you may know that California as a state banned affirmative action decades ago, long before SFFA was decided. And so they should have been in a compliant state for many, many decades, yet they are still seeing this enforcement activity. So against that backdrop, in early August, the president issued a memorandum directing the Secretary of Education to expand the scope of required reporting to provide adequate transparency into admissions, including accuracy checks of IPEDS data. That same day, the Secretary directed the National Center for Education Statistics, that's part of the Department of Education, to initiate a series of changes to IPEDS this year. A fact sheet that was released with all of this activity stated that there was a perceived lack of available admissions data from universities, and in the Trump administration's estimation, this being paired with the use of diversity statements and other, quote, overt and hidden racial proxies, that this was triggering a concern about whether race was still actually being used in admissions decisions in practice. So the fact sheet makes very clear that this is meant to be both an enforcement tool and will be information that is publicly available. Next slide, please. So quick pause for anyone who's not familiar. What is IPEDS? We love a good acronym in higher ed. The Integrated Post-Secondary Education Data System. It's a series of surveys on a variety of topics, not just admissions data. And schools are required to complete it by virtue of their receipt of Title IV funds entering into program participation agreements to get those funds. The categories of race and sex are actually already included in IPEDS and have been for some time, but we're going to talk through what more might be on the table for institutions. Next slide. So after the executive order and the direction from the Secretary, the National Center for Education Statistics published a proposal in the Federal Register with what amounts to a major expansion of IPEDS reporting. And what they're calling it is the Admissions and Consumer Transparency Supplement, or ACTS survey. What's very interesting about this proposal, though, is that unlike in the past, when changes to IPEDS surveys have been proposed, there is not actual survey questions yet that have been developed and that higher education institutions can react to. Rather, the NCES has basically described a wide series of types of data that they are expanding to collect. And what they want to do is to collect by race and sex pair across a series of different data points and then make comparisons, apparently. There are different sort of categories of data sought for applicants versus admitted students, and then people who actually ultimately enroll. I'm not going to go through all of them today, but essentially it covers things like GPA for high schools, ranges of family income, Pell Grant eligibility, parental education levels, admission test scores, students who are admitted via early action, early decision, or regular admission, merit-based aid, need-based aid, local, state, and federal government aid awarded, family income, and for graduate students, all of these similar categories, but then broken down by program. Next slide, please. There is actually more than what I just said, which is that for students who are ongoing, there would be data compared to, again, these race and sex pairs across different academic achievements as students move through their educational journey. So this would be things like average cumulative GPA at the end of the first academic year and thereafter. The cost of attendance, disaggregated again by test scores, by high school GPA, family income, graduation rates once students reach that finish line, and their final GPA. Next slide, please. There is still more. What they are looking to potentially ask from schools is a 5-year look back. They would go back to pre-SFFA data. And the stated goal of this is to, quote, track racial changes in admissions. This is where we get to an explicit goal, and this is, summarized in the slide here. Data alone is not determinative as to whether institutions are engaging in unlawful discrimination, but the department may use data to develop risk-based enforcement practices. I think particularly in an era where investigations are being conducted at sort of unprecedented rates and using procedures that many folks are unaccustomed to, I'm not sure that this qualification gives a ton of assurance. That's particularly so given the Department of Education has also recently, at the beginning of September, published their uniform agenda, and one of the regulations they're planning to promulgate are new regulations that would streamline OCR's ability to revoke federal funds. Next slide. So in publishing this information about the types of categories that they're looking to expand to, they sought public comments. Next slide, please. These comments closed on October 14th, so just last week, which is why we wanted to bring this update to you today. There were over 3,400 comments from institutions, a lot of advocacy groups, higher ed groups, and then members of the public. Interestingly, about 90% of the comments of those 3,400 were all identical comments. They were sort of copy paste, but from different people who were concerned citizens saying that they were concerned about the race of use in admissions. A lot of issues were raised by the higher ed institutions and the advocacy groups. I'm going to highlight just a few of them today. One is that data is not available. So a number of the fields that I rattled off have never been historically collected or were optional. And not everyone is required to complete a FAFSA, even going forward. And so there's real concerns about that 5-year look back, but even on a going forward basis, how we're going to be able to make sort of comparisons that have real accuracy if there are so many gaps in the data and some of these fields are optional. Privacy concerns, when we're disaggregating this data on so many different fields, there's concerns that for particularly a smaller school, you could get to a situation where individual students might be identifiable based on how granular this data is getting. Concerns about accuracy include self-reporting, whether students are going to just stop answering or won't answer honestly some of these prompts. And we know that that's actually what happened post-SFFA. There have been some studies done of data at certain selective institutions, and there was a small but significant increase across these schools where people just stop sharing information about their race one way or another. So that's going to call into question whether this data is accurate, and even if a school is reporting it accurately, right? A lot of comments fall into these sort of last buckets of scattered data in a decentralized institution is going to be really difficult to collect. We don't have staff at different higher education institutions that are, ramped up to be able to do this, and particularly if this is going to be on a expedited timeline. Next slide. There were also some procedural issues raised, raising questions about how it complied with different laws related to OMB approval, and a bunch of substantive issues, which I'll just really quickly, I'm running out of time, rattle through. The crux of it is sort of how much this over relies on quantitative measures is one of the big themes that, admissions, whether using race when it was lawful or now, admissions has never been just about someone's GPA or test score. Institutions are conducting a holistic review, and there's a lot of concerns that looking at the data in this way is going to present a really overly simplified picture. The look back includes time periods of COVID when all sorts of changes to admissions practices were happening that may influence that data and affect that data. Another one I'll just mention quickly is the tension with the Supreme Court decision in SFFA, where the Supreme Court really directed review to be conducted on an individualized focus. And so this sort of grouping and aggregating of data, a lot of the requirements talk about like different quintiles of GPA or test scores. It's really sort of in tension with what we've actually been sort of instructed to do by the court. Some schools and groups did raise alternatives, like, maybe we should run a pilot program for this or delay it for a year to give time for schools to prepare. On that note, next slide, please. And this will be my last slide for today. What you could do to prepare if you are an institution of higher education hearing all of this. So first of all, the impact of the government shutdown calls all of this into question about when we're going to hear more, when these comments are going to be reviewed, and when we're going to hear what the regulations will actually, or I'm sorry, excuse me, what the IPED survey data will actually be. Further complicating is that nearly all of the staff at NCES were laid off earlier this year. So at a time when there's this major new undertaking, there is very little resources from the government to support it. So I'll leave you with just, there's a few things you might want to think about on your campus to start preparing. You don't want to overly prepare, I think, because we don't know what the regulations are going to actually look like. You don't want to start collecting all of this data proactively when it could potentially change. But there's some things you may want to start to do to start to understand the scope of your data, where it's maintained, what types of systems you use for that data, where it's stored, whether third-party vendors are involved in this data, retention periods. And then the last thing I'll leave you with is the project management and role of council, thinking about, given the risk in this space and the government's very clear intention of how they plan to use this data, thinking very intentionally about how you use your council on your campuses or with outside council to manage and to plan for this new requirement. Thanks a lot.
Thank you, Britt. We appreciate your insight on this. I will now turn the program over to Candace for her update on the Safe for Kids Act. Candace?
Great. Thank you so much, Carrie. I have the great pleasure to be talking to you today about the Stop Addictive Feeds Exploitation, in other words, Safe for Kids Act. Next slide, please. Some of our goals today include understanding the background on why the Safe for Kids Act was passed. It was done so in the wake of the 2022 Tops supermarket shooting in Buffalo, New York, and we'll talk more about how that tragic event shaped this act. We also want to understand the requirements, definitions, and nuances of the Safe for Kids Act in terms of the proposed regulations from the Attorney General. And finally, we will be looking forward to see how the Safe for Kids Act will be implemented both by the Office of the Attorney General as well as private social media parties such as Instagram. Next slide, please. So the background of this act stems, unfortunately, from the 2022 Top supermarket shooting. In May of that year, An 18-year-old white supremacist targeted a Tops supermarket in a mostly Black neighborhood in Buffalo, New York. The shooter live streamed part of the attack on Twitch, which is a social media platform, until the live stream was shut down by the service within 2 minutes. 10 people were killed as a result of the attack, and 3 people were injured. The notion that has been shared is that this person who committed the attack was radicalized through his activity on social media. And with that in mind, there was an effort by lawmakers to try to stop this rapid radicalization of people, which they believe is leading to more and more of these mass shootings. There is also a lawsuit working its way through the state courts in addition to this act, alleging that social media algorithms are fundamentally dangerous and that social media has the potential to radicalize individuals to the point where they can commit acts of violence, such as the Top shooting. And one of those cases is the Patterson case in Erie County. It's now working its way through the Court of Appeals after being decided upon by the Appellate Division 4th Department recently. Next slide, please. The Safer Kids Act was passed by the New York State Legislature on June 7th, 2024, and it was signed into law by Governor Hochul on June 20th, 2024. And the act is scheduled to be enacted or to go into effect 180 days after the New York State Attorney General promulgates rules and regulations necessary to effectuate the provisions of the Act. Next slide, please. Next slide. So in terms of what is actually in this act, the goal is to prohibit online platforms, in other words, social media companies, from providing minors with what is called an addictive feed that uses data concerning that minor to personalize the material that the minor sees. And that is a feature that is linked to addictive behavior and is useful to social media companies because, of course, it extends the time that young people spend on social media to unsafe levels. The purpose of the act is to make sure that that addictive behavior is either prevented because the young person has not received adult consent to do this, or other measures will be put in place. So, for example, unless they have parental consent, the feeds on a minor's app, such as TikTok or Instagram, would be limited to posts from accounts that the users follow. Companies would be barred, prevented from sending notifications to these young people between midnight and 6 a.m. unless parental consent is granted. A big problem that we found through our work with school districts and in other areas that serve young people is that young people are actually sleeping less. They're staying up tied to these addictive feeds, and these nighttime notifications are part of the problem because they kind of fall down a rabbit hole where they go from one video to the next. And it has been found that it's tied to depression, anxiety, eating and sleeping disorders, and other mental health issues that children and teenagers are experiencing. And the proposed rules for implementing the provisions include standards for determining a user's age and parental consent. Next slide, please. These addictive feeds. Something is not an addictive feed if it's prioritized or selected based on the preference of the user. So, for example, if a young person has a favorite children's book author and they want to follow that author and get any type of news related to that person. Maybe a new book is coming out, or maybe there's feedback about the success of the last book. They would be able to get that type of feed if they specifically request that and if they have parental consent to do that. But these other types of feeds where maybe one person looks up a particular topic about, I don't know, celebrity lost weight through some type of bizarre eating behavior that's unhealthy. And then it spirals into this young person finding all of this information that can lead to anorexia or bulimia. That's the type of addictive feed that this legislation is going to hopefully lend a hand in stopping. Next slide, please. So we have proposed regulations from the Office of the Attorney General. It came out in on September 15, 2025, and the Office of the Attorney General released a 144-page notice of the proposed rulemaking. The Attorney General has stated to the Associated Press that children and teenagers are struggling with high rates of anxiety and depression, which is a growing mental health crisis because of the addictive features on social media platforms. And the Safe for Kids Act seeks to curb this behavior in all of the ways that we have talked about before, prohibiting addictive feeds, these nighttime notification, and getting more information on a minor's actual age and status. Parental consent is a big part of this. And when I first looked at this, I thought, well, how is that actually going to work? If a 13-year-old wants to subscribe to all of this and they need to get parental consent, won't they just click the button and adults won't actually ever know anything about it? Part of what is possibly going to be put in place is some type of verification that it is the parent. So, for example, a parent's email address or some type of visual image so that the social media platform knows that it actually is an adult consenting as opposed to a minor. Of course, there are ways to hack into or work around any of these measures, but the goal of this is to provide at least some type of prevention or hurdle to try to limit or perhaps stop this addictive behavior. Next slide, please. So when we're looking forward, there are options for users who are at least 18 to include a requested uploaded image that I talked about, or the user's email address or phone number to check against other information. So, for example, a parent could upload that type of information about himself or herself in order to make sure the platform is verifying that information against what the parent has submitted, as opposed to any type of workarounds that a child may try to implement. And the Office of the Attorney General has been um, they've noted that Instagram and other social media platforms themselves, even without this act, have been implementing various forms of age assurance in recent months. So even before this is actually going into effect, we recognize that some of the social media companies see the writing on the wall, and they are now starting to try to find ways to get some type of age verification for their users. Next slide, please. That is all that we have for today. I thank you so much for your time before I turn it back to Carrie and Stephanie.
Thank you so much, Candace. I will now turn things over to Stephanie so she can give us her presentation. Thanks, Stephanie.
Thanks so much, folks. Next slide, please, Kathy. So we just wanted to provide a quick discussion about paid sick time. We are 5 years just about into this law. As many of you are aware, back in 2020, New York State passed a law and it went into effect. September, employers had to start allowing for accruals, and January 1, 2021, employees had to be allowed to start using paid sick time, right? This applies to private employers only, but we wanted to give a quick little touch base, 5 years of reflection. What are the common questions that we're seeing? Carrie and I, in particular, and lots of others in our labor and employment practice have received a lot of questions about paid sick time policies, enforcement. So we really wanted to give a quick 10-minute overview on some of those common questions that we get. I want to preface this conversation, and I know I'm just speaking at all of you, but I think of it as a conversation because it's a little more interesting than just talking at you for 10 minutes. These are not one-size-fits-all approaches, right? Or policies. These policies, we have the New York State paid sick time law and maybe New York City, if that applies to you, or other state laws that have paid sick time requirements that might apply to you. Those are our boundaries, right? We have to comply with those minimum requirements. But your actual policy, there is some room for flexibility and customization, and it's going to vary, right? Depending on what your workforce needs. It might even depend on departments and industry in terms of what types of nuances and details do you need in your particular policy that works for you, right? If you are a member of the HR community, you might collaborate or connect with other HR professionals And what might be working for your friend or your colleague in their organization may not necessarily be the best fit for you. So, take all of these considerations into account and don't hesitate to contact your favorite labor and employment attorney when considering making changes to your paid sick time policy or your paid time off policy, whatever might apply, and work with them, because there's ways that we can help to really analyze your specific situation, values, goals, objectives, concerns that you're trying to address in your paid sick time policy or in enforcement. So diving into this, right, a common question we receive is a written policy or notice to employees necessary? So nothing in the actual paid sick time law for New York State requires a written policy, but we have existing labor law in New York State that requires employers to provide written notice of paid time off or holiday benefits, et cetera. So your vacation time, personal time, sick time, anything where you're giving people paid time off needs to be in a written policy. And what do you need to include in that policy? All the terms and conditions of using that, right? Accruals, important to have in there. When does an employee accrue? How does an employee accrue? What's your benefit year for purposes of that policy? A special nuance for New York City, the New York City sick time law does expressly require a written policy with very specific written requirements and contents. So if you are an employer that has employees in New York City, or that applies to you, make sure that your written sick time policy is in accordance with the New York City law as well. Can we limit carryover, right? This is one of my favorite questions. I say facetiously, you have to require carryover. It doesn't make a lot of logical sense. New York State Department of Labor has taken the firm approach and has reiterated that the law requires carryover of all accrued unused sick time year after year. If you use a one bucket methodology, right, you have one bucket of PTO time to comply with sick time, vacation, personal, et cetera, you are stuck with use, carryover, and accrual requirements of paid sick time. So unfortunately, yes, you are stuck with that carryover requirement. However, what makes no sense and what frustrates several employers is that the law does allow you to impose a cap on the use of sick time per year. If you are in one of those small or medium-sized employers, it can be 40 hours. If you have over 100 employees and you are a large employer, it's 56 hours per year. That you have to allow employees to use at least 56 hours per year or 40 hours per year, depending on your size. But you can impose a cap on use, right? This does create somewhat of what we call a ghost bucket of time, time that's carrying over year after year. If it's unused, that employees may never be able to ever tap into or use. Again, work with your labor and employment attorney to discuss those concerns you might have. But technically speaking, to technically comply with the New York State paid sick time law, you must carry over all the time year after year. One bucket methodology, we talked a little bit about those nuances already, right? You're stuck with complying with the use, accrual, and carryover requirements of paid sick time. So yes, you can have one bucket of time as long as it's the minimum amount of hours, depending on your employer size. That is for any purpose, right? Sick time, vacation time, personal time, whatever time, anytime, right? But you're going to be stuck with complying with those minimum requirements under sick time. So what has become, some of the common issues we've seen as of recent is that employers who perhaps used a one bucket approach back when the law went into effect are finding it difficult to administer now because all of that time is not further allocated or designated as protected paid sick time. So when someone uses paid sick time, remember, they cannot be disciplined or a point can't be assessed against them. It can't be taken into account in a negative way in any employment decisions. So when you have the one bucket method, a lot of employers are not tracking if it's personal time, vacation time, or sick time. And so you're stuck with that risk. You can't discipline someone for using that time without significantly risking a violation of the sick leave law if they use that absence or that paid time off for a qualifying sick leave purpose. So I have had several clients come to me and try to peel apart those policies in the last few years. Again, because it just makes more sense for their workplace, right? Attendance is a little more manageable when we have designated sick time that's protected, untouchable, can't consider that in employment decisions, and then all the other paid time off. Again, I encourage you to, work internally to figure out what your goals are, what your concerns are, what your priorities are, and then contact your labor and employment attorney if you do have concerns about maybe making a change to your buckets or your methodology and how you're providing sick time. I have had a couple of employers who had separate buckets and want to combine it into one bucket because it works better for their workplace. Again, there's no one size fits all approach. It's really going to be specific to your needs and your concerns, your goals, and what you're trying to accomplish within your workplace. Can we have different policies for different classifications of employees? Yes, as long as it's based on a legitimate classification. So you're not, providing separate time off policies for protected characteristics like sex or age or race, right? We can't use those as classifications for purposes of employment policies and having different policies. But you could have a PTO or a sick time policy for your exempt staff and employees, and one for your non-exempt staff. Or another common one that I see or that clients come to me with are having a full-time policy and a part-time policy. Perhaps for those full-time folks, they're providing them with front-loaded PTO or vacation or sick time, and for the part-time folks, it's accrued. That's okay. And just make sure that those policies are clear who they apply to. Policies for the multi-state employer, as I mentioned a little bit earlier, make sure, I think it's very common now for employers to have remote employees or even operations in different states. Don't assume that a New York State sick time compliant policy is going to be compliant with all other sick time laws. There are, believe it or not, more generous policies and laws in other states that require more time off, or they are more than just sick time, right? Some states we have seen a trend in developing these paid time off policy or laws and requirements. So it's not just providing employees with sick time, but employers have to provide employees with paid time off that can be used for any purpose or other more expansive purposes than just sick time. So make sure if you have employees in other states, even as few as one, that you are doing some due diligence. You're looking into making sure that you're complying with those paid sick time laws that apply in that state, as well as localities. Those are also common. I know outside of Chicago, or in Chicago rather, in that county, and I think the city as well has their own sick time law. New York City has its own sick time law. For example, Pennsylvania does not have a state sick time law, but Philadelphia and Pittsburgh, those areas do have their own local sick time laws as well. So making sure you're just doing your homework and your own due diligence, that you're complying with those other applicable sick leave laws that might apply to your employees. Next slide, please, Kathy. And then with respect to other common issues of application and enforcement, right? What do we do if we ask for documentation and the employee doesn't provide it? Remember, there are, again, very strict limitations on what you can provide in terms of documentation or what you can require an employee to provide and request, right? You can't ask for confidential information. You really can't ask for details regarding the medical condition or anything like that. The most you're really going to be able to ask for is a document from the healthcare provider that says the date that they took the leave and that it was qualifying paid sick time leave, or an employee attestation. And again, that's only going to be permissible after 3 consecutive days of absence, right? And that's 3 consecutive work days or scheduled work days, not calendar days. So, the guidance that we have from New York State is clear that you can't deny the sick time because they haven't provided the documentation. But if they've already taken it and your policy requires providing documentation when they come back to work, what do you do then, right? It's going to depend on your risk tolerance. I think there is risk in asking for documentation, or not asking for documentation, but taking some sort of disciplinary action if the employee doesn't provide the documentation. But I think it's going to depend on your facts and circumstances and what your risk tolerance is. Also, consistency with how you enforce that policy and apply that policy with other employees. That will also be relevant and important. So work with legal counsel to make sure you're comfortable if that comes up on how to address that situation. Can employers require an employee to use accrued sick time if they know the employee is going to be absent for a qualifying sick leave purpose? I think reasonable folks can, have different opinions about this. There is one position where the language in the statute itself says upon request of the employee. Many of us have interpreted that to mean that the Department of Labor thinks that it should be at the employee's election, right? That said, if you take that approach, if the employee chooses not to use accrued sick time and they're absent, you may be able to apply your attendance policy. Again, as long as that absence is not protected by some other leave protection or law, right, you may be able to apply that attendance policy because it's not going to be protected under the paid sick time law. Others might opine that yes, if we have to provide you with this amount of time, it's a qualifying sick leave purpose, it's protected, we're going to require employees to apply it. Again, this is going to depend on your comfort level, your need, your concerns, your values, and your goals, and your work environments and your organizations. So work with legal to figure out, again, what you're comfortable with and making sure that you are able to implement whatever that policy is. Can employers use an existing PTO policy to comply with the prenatal leave law requirements? Generally, the answer to that is it has to be a separate prenatal leave bucket, right? If you provide employees with, say, 60 hours and you're an employer who has to provide 40 hours of a sick time and you provide the 20 hours of prenatal leave, remember the prenatal leave law went into effect January 1 of 2025, and that requires private employers to provide another bucket of 20 hours of time for individuals and employees to take leave for prenatal healthcare appointments and healthcare services. So unless you're in a collective bargaining setting, there may be an argument there regarding negotiation of your contract about, other benefits that might, trump or be comparable to or in placement of the prenatal leave as provided in the paid sick leave law. But if you are not in that bucket, all other employers, you have to have a separate prenatal leave bucket of time from apart from your PTO time. This is also important because the prenatal leave law is very clear that employees have the right to choose if they want to use that time or not. So if they don't want to use that time, they cannot be required to use the prenatal leave time allotted to them. Again, whether or not it's protected under some other law might depend, right? Arguably now with prenatal leave and the accommodations you have to provide under the Pregnant Workers Fairness Act and New York State Human Rights Law, those might need to be accommodations that you have to provide in terms of unpaid leave time. So you may not be able to hold them accountable under your attendance policy. But again, I encourage you to work with legal counsel. These issues, especially attendance management, complicated leave laws, they are complicated. They must be evaluated on a case-by-case basis. So don't hesitate to seek some support from your favorite labor and employment attorney to walk with you if you have any questions about complying and navigating those issues as they come up.
Thanks, Steph. As Stephanie mentioned, yeah, we do work with clients all the time on paid sick leave compliance, and we're always happy to help if you have questions. Also, this is a great reminder, particularly if you haven't looked at your sick time, you prepared it 5 years ago and haven't looked at it since. It's a good reminder to dust off your policy and review it again in light of what we know now. I know that we are well beyond the 30 minutes, so I'm going to wrap this up quickly. Thank you for tuning into the webinar today. As always, the contact information is on this slide here. Please feel free to reach out to any of us with any questions. Gabe will be hosting next week. Please join him if you can. Thanks so much again for joining. Have a great rest of your day.